Okay, what we're going to be doing today is we're going to go through something useful. You need to watch this. Alright, what that is a copy of a document, although it's been edited to take out personal information. What it does is it represents, how I got started with this is a guy named Lackluster. I sent him up the case, if you look at my other videos on Castle Rock retaliation. Well, this is an ongoing problem in Colorado where under 42 it's Colorado Revised Statute, CRS 42.3114, they pull people over for expired tags, when in fact that's not what they should be doing unless you're the owner of the vehicle. I'm going to go through this argument and one of the documents that I filed in a similar case out in Arapahoe County, because this document allows for those persons that are fighting simple traffic infractions a way to be able to frustrate the court to a position where they have to dismiss the case. And if they choose not to dismiss the case, then they have to answer the questions. And what this is, if there's no way to print that out, sadly, but you can read through it and you can follow along here and there. But I don't have a way to be able to upload it into the cloud so people can download it as of yet. If later time after this goes up, where I'm able to find a link where I can upload it, or I put up my own server, then that's what I'll do so that people can download the document in PDF. But it won't be editable because I use what's called latex to create these documents. I don't use Microsoft Word because Word is for people who don't know how to use a computer. Alright, but you could always copy and paste into Microsoft Word. Alright. Now this is called an answer in the nature of a motion for declaratory judgment and injunctive relief and in the alternative to dismiss. All right, a declaratory judgment action is where, well, let me back up. Because it's a traffic infraction, we'll go through this, but because it's a traffic infraction, it's considered a case of purely civil nature. All right, it's purely civil, which means you need to file an answer to the charges. You can't, it's not like a normal traffic ticket where you can just show up in county court and defend yourself in a criminal trial. The traffic infractions are considered purely civil and you need to file an answer, right? So that's why this says answer in the nature of a motion for declaratory judgment. For those people who don't know what a declaratory judgment is, it's a request to the court for them to be able to declare that something, a statute, rule, regulation, ordinance, whatever it is, a municipal ordinance, is unconstitutional either on its face or in its application, right? So then, the injunctive relief means it's an order from the court against, in this case, policing agencies from pulling people over and writing them tickets when they know that the person who's driving the car is not the owner of the car, in this particular case. You might have to modify it. There's a lot of people out there. I can understand why you don't understand a lot of this. This is why I'm going through it, in an attempt to help those persons that do have a basic understanding of how the law works, how to be able to start the process of learning how to defend yourselves. So, and then the alternative to dismiss. Now, before we get into this, what I did is I went into court, Arapahoe County, with this document. and I handed it to the judge. Well, put it on the podium. The clerk comes over, picks it up from the podium, and hands it to the judge because the judge is stupid enough to believe that social distancing and masks prevent the spread of viral and bacterial infection. In other words, the judge is a moron. All right? So as soon as that judge took that motion, he lost jurisdiction, and there's a reason for it. This isn't, patriot nonsense. This is how it works. When you file a motion for declaratory judgment, you have to understand that when you're in a traffic infraction court, right, or you're in a county court, magistrates can't make rules of decisions of law. They're not allowed to do it under the rules. Once again, that's been pled in that document, right? So this judge sits down and he reads the motion, and then he denies the motion. My retort to that is you can't dismiss it. You can't deny this motion. You don't have any jurisdiction. It says you only have two options. You can either kick it upstairs to the district court, where they can make rules of decisions of law on declaratory actions, right? Or you have to dismiss. You don't have any other options. And from that point forward, every time he said anything to me, I simply replied, you don't have the jurisdiction that you think you have. It doesn't matter what you have today. It says you've accepted that motion. That motion now must be kicked up to a judge that can make rules of decisions of law. Well, of course, he went through this fake trial, quote, hearing with a stupid cop. The cop admitted that I had, when he pulled me over, I had told him that only the owner of a vehicle can be written for a violation of expired tags in Colorado, which is what the statute says. And the judge, he had nowhere to go with it, and he looked at the cop and he says, I have to dismiss this ticket. So what it boils down to is he only had two choices. He either had to kick it up to the district court, where the district court could rule, or he had to dismiss. Now, if he were to kick it up to the district court would have to decide these issues of law. Now, if you understand that these traffic infractions and what police are there for is revenue enhancement. They're there, the police exist, well, on the surface they're there to some modicum amount of protection. Although there is a case out of Castle Rock, Colorado, where the Supreme Court said that the police have absolutely no duty to defend or protect. Right? They don't have to even show up. Look at Uvalde, the cowards down in Texas that let all those kids die while they're sitting outside for over an hour. Well, there's no private right of action against those police for not doing their job, because the Supreme Court has already ruled in a case that came out of Castle Rock that the police have no duty to defend and no duty to protect. Right? It just simply doesn't exist. So anyway, I prevailed. The judge had to dismiss the case, and I want to be able to go through some of this today. You can read it. You go back and you just pause the videos and read through the document. I'm going to go over some highlights in the document. So the page 1 is jurisdiction. Just read it. It's going to be the same for anything you might want to do, and in traffic tickets in the state of Colorado. All right. So it's part 2 analysis. Paragraph 9. Statute reads, now I'm going to read this out because it matters. Every vehicle registration under this article shall expire on the last day of the month at the end of each 12-month registration period, and shall be renewed upon application by the owner. The payment of the fees required by law and in accordance with section 42.3.113 subpart 3, not later than the last day of the month following the date of expiration. No license plates other than those of the registration period to which they pertain shall be displayed on the motor vehicle operated in the highways of Colorado. A person who violates any provision of this section commits a Class B traffic infraction. Right? Now let's go through that. No license plates other than those of the registration period to which they pertain shall be displayed. What that means is that if you have an expired registration and you put fake tags, month and date on the back of that plate, I've gone through this before, then you have expired plates. All right? Because the plates themselves, the tags, don't refer to the dates that are on your registration. It doesn't have anything to do with the expired registration. All right? Because it's all a matter of taxation. Once again, what is it? Remember the case? This is you lose your liberty through contract. You're driving the state's car on the state's roads, and you got to pay a tax, which is what? That license plate is what? Permission granted by competent authority to do that which is otherwise illegal. And so they put that license plate on there to show that you've paid your tax on the state's vehicle. All right, so now let's go to paragraph 10. CRS 423114 is incorporated by reference as if set forth fully herein. Yeah, you need to incorporate in any documents. In other words, if you're defending yourself at trial or in any way, in a hearing, in this case it's a civil hearing, you need to incorporate into your pleadings the statutes or ordinances, municipal ordinances, upon which the state is moving against you. All right? You do that because then they take judicial notice of that particular statute or ordinance. All right? Paragraph 11. Okay, a traffic infraction is defined in CRS 42411701 in pertinent part, because it goes on. It says it is a traffic infraction for any person to violate any of the provisions of Articles 1, 2, 3, and it goes on and on and on. And then it says, in which of course 423114 qualifies for this. But what matters is at the end of that subparagraph 1, such a traffic infraction shall constitute a civil matter. In other words, it's not criminal, it's civil. Right? So you're going to have a quasi amount of civil rules and criminal rules that they use, what's called the Colorado Rules of Traffic Infraction. Right? Under subparagraph 2A of that section, 42411701, for the purposes of this part 17, judge, the term judge, shall include any county court magistrate who hears traffic infraction matters. Okay? And what they do is that when you have a traffic infraction, you're moving towards what's called a police court. It's a traffic infraction court. It's not a county court. It's below county court. Right? It's below municipal court. It's a traffic infraction. It's in essence a star chamber. Right? They don't use the rules of civil procedure for either county court or municipal court. They use their own set of rules, and we'll be going through that in just a second. So, in fact, that's the next paragraph. Paragraph 12. Pursuant to Colorado rules for traffic infractions, all right, and I put CRTF there. I don't know why, but that's a typo. Throughout the document, when you see CRTF, it should be CRTI, obviously. Colorado rules for traffic infractions. These rules are promulgated pursuant to Section 13.65019 of the Colorado Revised Statutes and govern practice and procedures for the handling of non-criminal, that means civil, traffic infractions, which are defined as civil offenses in Sections 42.41701, which is what we just read. All right? The purpose of these rules is to provide for the orderly, expeditious, and fair disposition of this class of traffic offenses. For this purpose, now this is where it matters, and that's why it's highlighted in the document. The rules apply concepts of both civil and criminal law as deemed appropriate to establish informal hearing procedures in the county courts. Right? And by county, they mean within the county. They don't mean the county court because it's a special court. CRS 13.6501, paragraph 4, in pertinent part, right? Subject to the provisions that no magistrate may preside in any trial by jury, county court magistrates shall have the power to hear the following matters. Subpart A, Class 2 misdemeanor traffic offenses and Class A and Class B traffic infractions as defined in 42.41701. Subparagraph 5 on that, except in Class A and Class B traffic infraction matters, before a county court magistrate may hear any matter, all parties thereto shall have waived on the record their right to proceed before a county judge. Now, normally what happens is if you get a ticket that ends up in front of the county court and you have a county magistrate sitting there, his plate may just say judge. And you need to ask that judge, Your Honor, are you a magistrate or are you a judge? And he'll tell you. And if he says you're a magistrate, you can refuse to have a trial in front of the magistrate if you've got questions of law. What a magistrate does is he handles what are called ministerial matters. Perfunctory, paperwork moving matters. If you have a defense, and especially if you have a defense at law, right, that you know that you've got a defense at law, then you need to go, Your Honor, we need to be in front of a judge. And the judge will go, great, and he'll stamp it and he'll send it over to county court judge. Right? If you have no defense and all you're doing is going through the motions, then you can be in front of a magistrate, and it doesn't matter because he's not making rules of decisions of law. He can be a finder of fact, he can hold trials, and he can enter judgment against you, right? But if you've got a legitimate issue, a complaint at law that you need to have heard, then you just object for the record, and you know, says, I want to see a judge, and they'll just move it upstairs. However, with respect to these traffic infractions, as we'll go through this, it says you cannot object to the magistrate's jurisdiction because it's a purely civil matter, and the normal rules don't apply. All right. So let's look at paragraph 6 of that. Right. Right. Yeah, it's 13.6.501, paragraph 6. Right. Magistrates, when handling county court matters and Class A and Class B traffic infraction matters, and where the parties to such proceedings other than traffic infraction matters shall have waived their right to proceed before a county judge, shall have all the jurisdiction and power of a county judge, and their orders and judgments shall be those of the county court. And that's what they're saying, is that if you're there for other reasons other than traffic infraction matters, and you don't waive the magistrate's jurisdiction, then that magistrate's jurisdiction is as good as a normal county judge. All right? So, of course, it depends on what it is you're doing. But if you've got a traffic infraction matter, then you can't waive. You can't waive it. All right? So as you go down to this document's paragraph 14, where it says CRTF Rule 2 states, right, these rules, Colorado Traffic Infraction Rules, Rule 2, application, these rules apply to actions in which only the commission of statutory traffic infractions are charged. In any action in which the commission of a traffic infraction and a criminal offense are alleged in one complaint, all charges shall be returnable and judgment shall be entered pursuant to such action shall be treated as one proceeding governed by the rules and statutes applicable to the alleged criminal offense. And what that's saying is, in layman's terms, is that if you have a traffic infraction on your ticket, simple traffic, and let's say you don't have proof of insurance, right, or you have anything else that would be a state charge, right, that would normally, that means it bumps you up to the normal county court. And if you've got a serious state charge, it can take you to the district court. Let's say you've got fleeing, evading, or you have obstruction of justice, or like they did here in Castle Rock, where they charged me with obstruction. All right, well, that kicks it up into the county court, and if it's something serious, it'll send it up to the district court. But that's what they're saying here is that if you've got both a traffic infraction and in essence, a criminal traffic charge, then they'll bump it up automatically into the county or the district court. All right, you won't be heard in a traffic infraction court. All right. CRTF, which is Colorado Rules of Traffic Infraction, Rule 8 says, discovery shall not be available prior to hearing. This one actually caught me off guard because I was mad about this ticket in Arapahoe because I told the stupid cop, you can't write tickets for 114 for somebody other than the owner of the vehicle. But he did it anyway, and I was mad, so I sat down and I drafted all this. I went through all the statutes and all the rules and regs to be, and put this together because I want to challenge this up to the Colorado Supreme Court. But the only way you can do that is you have to get it kicked into the district court so you can get a declaratory judgment. Right? So it says discovery shall not be available prior to hearing. Well, why was that a matter? Well, because I wanted the cop's body cam, and they wouldn't give it to me. Why wouldn't they give it to me? Because I'm in a traffic infraction court, right? And no discovery is available because you're not under the rules of civil procedure. You're under the rules of Colorado traffic infractions, right? So what do? The next time I get pulled over for this nonsense, I'm not going to give him my proof of insurance, even though I have proof of insurance. So what does that do? He'll write me for failure to provide proof of insurance, and that will automatically kick me up to the county court, where I can then drop this on a county court judge, show my proof of insurance. They have to dismiss the ticket there, and then it'll get kicked over to the district. Well, hopefully it would get kicked over to the district court for the declaratory relief. And declaratory and injunctive relief is how we say it. All right. Rule 10b of the Colorado Rules of Traffic Infraction. The charges shall be dismissed if the final hearing is not held within 6 months from the defendant's answer, pursuant to the provisions of Section 42.41710, Subpart 3, CRS. All right? Well, that's where it tells you that you have to file an answer. Colorado Rules of Traffic Infractions, Rule 10b, says you have to file an answer. If you don't file an answer, then you've demurred to the case. All right? You've said, well, you've got a legitimate point. You have to file an answer. If you don't file an answer, just like you would in a normal civil trial, then they can take default judgment against you, and all they're looking for when you go to the hearing is evidence to be able to support the claim for the entry of judgment, entry of default judgment. All right? Because you didn't bother to file an answer. So on traffic infraction cases that are purely civil, you have to file an answer. You have to say, I didn't do it, and here's why. All right? All right, so, and then Rules 11b2 and 11c state, the officer shall offer sworn testimony and evidence to the facts concerning the alleged infraction. After such testimony, the referee and the defendant or counsel may examine the officer. Now, why does this all matter? Well, it matters because there's no prosecutor prosecuting the case. When you show up at these traffic infractions, the police officer is prosecuting the case. Well, what does this go on in the next couple of pages? Unauthorized practice of law. See, you have to understand that the caption of the ticket will say the people of the state of Colorado versus fill in the blank, right? Defendant. Well, if it's the people versus, the police officers don't have the lawful authority to prosecute in the name of the people. Only district attorneys do. County attorneys, prosecutors, right? So where from does that cop get the authority to be able to actually handle the case? Normally, you would have in this case, it was Arapahoe County. It wasn't within a city. Arapahoe County would have a county prosecutor that would then call the police officer, puts the police officer on the stand, swears him in, and sits there and asks him all the questions needed to be able to lay the foundation for the conviction. That's the job of a prosecutor, is to protect the interests of the people. But these are star chambers. You have to understand that these so what you have is you don't even have a magistrate judge. You have a magistrate judge who's acting as a referee. Right? Why? Because it's a star chamber. So he's a referee, and you have a police officer prosecuting in the name of the people. And the cop doesn't know anything. He has no law degree. He has no experience. He doesn't know what cases should or should not be prosecuted. Right? So, the Colorado rules for magistrates, right? We're talking about paragraph 21 here now. It says, no magistrate shall have the power to decide whether a state constitutional provision, statute, municipal charter provision, or ordinance is constitutional either on its face or as applied. Questions pertaining to the constitutionality of a state constitutional provision, statute, municipal charter provision, or ordinance may, however, be raised for the first time on review of a magistrate's order or judgment. Now, what that's saying is the magistrates do not have jurisdiction to make what's called rules of decisions of law. Okay, he can't decide the constitutionality of anything. But this one also provides that if you've got a magistrate's order, that you can raise a constitutional issue on appeal. Right? See what it's saying? However, be raised for the first time on review of the magistrate's order or judgment, which means you're appealing to the next higher court to have the magistrate's order reviewed using a constitutional standard. All right. Next page. So we're going to go in summary here. Paragraph 25. In summary, the allegations before the court in this case was a Class B traffic infraction. The action is being held in the county court, in this case before a county magistrate judge acting as a referee. The action is purely civil in nature. As found in all civil cases, the defendant is to provide an answer. The magistrate/referee is precluded from being able to hear motions or make decisions of rules of law with respect to the constitutionality of a statute or the rules on their face or application. And then F says, therefore, this case needs to be removed to the district court. All right? Because what did I say? Declaratory judgment actions, they're handled by the district court. All right? And here's the argument. Paragraph 26, right? Part 3. CRS 423114 and promulgated rules thereto as applied to the county court in the instant case are unconstitutional on their face and in their application. You got to say it plain and clear. Why do you have to do that? Because when you move to appeal, the issues have to be presented to the trial court in clear, simple terms, unambiguous language. All right? If the trial court just blows past it, that's okay. But you have to make what's called a contemporaneous objection. Your Honor, you didn't answer the question. It says, I object for the record. And he doesn't have to answer it. He can just ignore it. But you have to preserve your issue for appeal, and the only way you do that is if you're actually there, is you have to make what's called a contemporaneous objection for the record. You go, Your Honor, I asked you this question about the constitutionality of a case. Well, we're talking about in the district court here. District court he refuses to answer the question with respect to constitutionality. You have to just object for the record, and now you preserve what's called I just said it, a contemporaneous objection for the record. All right? So then paragraph 27 describes what constitutes the practice of law. Like I just said, so the police officer is engaged in the practice of law, and paragraph 27 shows what the unauthorized practice of law is, and of course then it shows that he's not allowed to do it. Paragraph 28, as stated above, which is paragraph 27, the caption of the citation is "The people of the state of Colorado versus," and therefore the state's interest must be represented by the district attorney's office. Only the DA's office can represent the interests of the state in the name of the people, which is true, right? The county attorneys actually handle, you know, Arapahoe County versus so-and-so, all right? Or the city of Arvada versus so-and-so. It goes to a municipal courtroom, all right? You have to understand that most judges are idiots. They have no idea what they're doing. It's very rare you run across a judge that has any clue of an idea. Yeah, they got I call them clowns in black dresses. Clowns in black dresses. These guys were nothing more than incompetent attorneys that through political appointment or otherwise, they get appointed to the bench. They go through 6 months of training to be a judge. They have what's called the bench book sitting there. And most if they were competent attorneys, why would they be judges? Judges don't make anything. They make like what, $120,000 a year? Denver County Court judges make more than state district court judges do, by a substantial margin. By a substantial margin. But if you're a practicing attorney in a firm, you're making $200,000, $300,000, $400,000 or more. You can be just in arbitration. You can be arbiter and you're making $500, $600, $700 an hour doing just arbitration, right? And it's nowhere near. A lot of retired judges do arbitration, right? Then in Colorado, this one actually is right. It's CRTI Rule 11B2 says. I'm looking at paragraph 29 here. The officer shall have offer sworn testimony and evidence to the facts concerning the alleged infraction. This is impermissible. Only an attorney or pro se litigant may offer evidence to a court during trial. Period. And that's it. That's it. You've got a prosecutor or you've got a pro se litigant, and that's it. This moves to what's called the proper party in interest. Obviously, the defendant, if he's representing himself pro se or pro per, this individual is a proper party in interest, and then the people's interests are only represented by an attorney, which is the whole point of having an attorney speak on your behalf. Okay, now we're going to jump down to paragraph 31. 31 says, this very issue as to whether CRS, that's Colorado Revised Statutes, 423114 applies only to the owner of the motor vehicle has already been decided twice. Right? And there was 2 other cases. One was here in Douglas County. I prevailed, which is one what the video was all about when the stupid cops in Castle Rock pulled me over. And then not even a couple weeks later, I got pulled over in Jefferson County. Right? And then that got kicked up to the county court because I didn't have proof of insurance in the car. I had proof of insurance, but I didn't have it in the car. And so because of that, they kicked it up to the county court. And the county court judge agreed and then dismissed that charge. And of course, I just showed my proof of insurance when I showed up, and then they dismissed that charge. So I prevailed there also. On paragraph 32, the plain reading of this statute, right, that's the 423114, and the attendant regulations are clear in their meaning. The purpose of that statute is to prescribe the behavior of changing the tags to reflect a current registration date inconsistent with the date reflected in the registration. Colloquially, if the registration is expired, people try to put fake tags on their plates so they don't get pulled over. That's what that statute's about. All those naysayers think that if you're driving around with expired tags, they should be towing your car. You don't know what you're talking about. The number of people out there that have absolutely no education, no capacity, ability, or intellect in law is profound. I mean, I'd venture less than 1% of society could defend themselves out of a simple traffic ticket, and that includes most attorneys. All right? Now we're going to go to the next page, page 8, and then to paragraph 40. So skip on down. Then CRTI Rule 12B, for example, states, the referee may find the defendant guilty of or liable for a lesser included traffic infraction if based on the evidence offered and enter appropriate judgment. My comment is this seems to be inconsistent with Howell v. People, 178 Colorado 248, a 1972 case, stating an information is sufficient to apprise a defendant of the charge it faces if it sets forth for the essential elements to be included in an information charging the crime. In other words, what this is saying is that this stupid Colorado Rule Traffic Infraction Rule 12b is saying is that the charging document charges you with one infraction. But if during trial the officer testifies to something else that's not in the charging document, the judge is allowed to be able to convict you of a lesser included traffic infraction. Well, my next paragraph on that, paragraph 41 on page 9, talk about being surprised at trial where the court sua sponte means on its own motion, may find a defendant liable for a lesser included with no prior notice. They're supposed to give you notice before you go to trial what the charges are supposed to be. They don't get to just make stuff up as time goes by, right? The lesser included offense doctrine places some burden upon the defendant to determine specific charges. It's a case called Cook, right? Next paragraph, 42. There are no jury instructions available for the violations for 42.3.114. This creates indefiniteness, which leaves to officer, court, or jury the determination of standards in a case-by-case process, which invalidates legislation as being violative of due process, as contravening the mandate that an accused be advised of the nature and cause of the accusation, and as constituting an unlawful delegation of legislative power to courts or enforcement agencies. That's Dominguez versus City and County of Denver, 147, Colorado 233. It's a 1961 case. And what that's saying is that you're not allowed, you have to provide jury instructions for a charge, right? So if you got a criminal charge, before you go to trial, one of the things that prosecutors are going to provide to the defendant's counsel and the court is going to be jury instructions. And those are the individual elements that the prosecution has to show at trial to be able to so the jury or the finder of fact is able to take the facts, the laws provided to them by the judge, and apply the evidence to the facts within the scope of what the judge says the law has to be. And what I mean by that is sometimes you'll hear testimony, as an example, that's not admissible. And if it's not egregious, it's not egregious evidence, something that would cause mistrial, the judge will instruct the jury to disregard that particular piece of evidence. You're not allowed to consider it when you're in the jury room deciding the case. You're not allowed to not even consider it, because oftentimes people will misspeak. A lot of evidence. A classic example of this is there's an individual being charged with a sex assault, and the plaintiff in the matter, the victim in the matter, is a prostitute. Right. Well, that doesn't have anything to do with anything as to whether or not the alleged, the defendant, the alleged perpetrator, actually committed the crime of rape. Right. And so if it comes out at trial that the victim of the case is a prostitute, that it has nothing, and in fact that could be very well enough to be able to get a mistrial, because that's so egregious in a lot of people's eyes. So then it goes on, proceeding to trial with an action brought in a government entity. All right, I'm not going to go through all that. You can read it for yourself. So there we go. In a nutshell, if you use these arguments for traffic infractions in the state of Colorado, right, and you read through all of these, you have to read the statutes, read the regs, read the rules, then you can sit down and you might be able to find, if you've got a legal way out, you draft a document that's very, very close to this, similar to this, and then you may be able to prevail at trial simply because the judge doesn't want to have to kick this up to the district court, and they'll just dismiss the case. So I'm trying to, in this channel, as much as I can over time, provide useful information to those persons that would be able to make use of it, that have at least some modicum amount of interest and or background in law to be able to defend themselves from the clearly criminal incompetent court system. Our court system, our judges, they're broken, and they need to be fixed, but people don't listen. The only way this is going to ever change is if you vote people in that are going to make meaningful change. And it's not going to come from your standard Democrats. They've all gone socialist and communist, and most Republicans are just rhinos. The Republican name only, and they don't. And most of these people who are sitting in the legislatures, they have no education in law. They have no education in history. Most of these people are out there for their own self-serving needs and interests. And you keep voting dum-dums into office. That's why Trump was so good. Is that he made a lot of mistakes, but the greatest thing that Trump did was to be able to put what appear to be conservatives on the United States Supreme Court so that we could overturn a lot of these really bad cases that have been sitting out there for decades. So if at the local levels, we need to start voting in those individuals that are constitutionalists, original constitutionalists, libertarian-minded individuals who believe in liberty, personal responsibility, and fundamental constitutional principles. Thank you for the time.